Good evening, everybody, and welcome to our presentation sponsored by the Purdue Law Society, selecting primary and secondary sources and writing a case brief. I'm going to just give it right on over to Professors Valdez and Nolan and let them take over. So welcome, everybody, and you're in for a very informational hour. Take it away.
Good evening, everyone. Professor Valdez and I are both full-time faculty. We both have been here close to 20 years. We are happy to do this is becoming now a yearly tradition. This is our second year in a row presenting on this topic. So, maybe this is our new January tradition. So we're happy to be here to present on these two very important topics. This will be recorded, and you can, I believe that we will also send the PowerPoint out so you can have this as a reference. You can have the recording as a reference in case you end up needing it down the line for some other class. So thanks again for coming tonight and taking time out of your busy schedules to be here. So we're going to begin by talking about the different types of legal sources. And I remember, we're in an interesting time period right now when it comes to legal research. I think all of the professors here tonight, we all kind of went to law school at that point in time where we were transitioning from physical libraries, brick and mortar libraries, where you had to learn the books, you had to touch the books, and your professors, wanted you to actually learn this book research, and you've got to use the library, which is valid. But then we were also kind of crossing over, probably, and I think all of us probably had Westlaw reps coming into our classroom, and they used to actually teach us how to use Westlaw in our legal research and writing classes, people from the actual company. This is when it was being implemented. So we were sort of at a crossroads. And so nowadays, doing computer-assisted legal research is pretty commonplace. I was just revising my course, Introduction to Legal Technology, and I was noting that a lot of the articles about computer-assisted legal research were from like maybe 2010, because it's sort of like we're done discussing, this transition. We've made the transition, right? So clearly we have. The one thing I think we're in this other period of transition now is that we are, it was kind of like, paying all this money for Westlaw, paying all this money for Lexis. There were other kinds of, the CD, the libraries with CD-ROMs. We are now in another period of transition where legal sources are also available, or there's a variety. It's not just Lexis and Westlaw. There are other sources, credible sources that we can use too. However, that's great. We can access the legal resources in so many different ways. Yes, Hope, right. Yes, absolutely. We can access these resources in so many different ways now, but we still have to have an understanding of, okay, what is this? Like I said, and when I was in law school, we were taken to the library. They showed us the actual books. Here are these different sources. So we sort of got an idea of like, okay, this is where these books go and this is what they do. We have to do it in a different way now, which of course is fine because we're all very used to technology, and so it is important to understand, though, what are these sources that we're looking at? Like we're accessing them online, but what do they do? How are they useful to us? So we have our primary sources. This is, sort of like your primary sources of law. Constitutions, our federal constitution, our state constitutions. This is primary. This is I always think of it as like the gold standard, of source. Statutes are actual laws on the books. Very important sources. Very, primary is, the top of the line. Then we have regulations. As you know, when administrative agencies promulgate regulations, they have the full force and effect as a law, as case law. You know, they're just sort of, they're all equal. And then cases, of course, these are all primary sources of law. So when a judge renders an opinion, that essentially becomes law. Then we've got secondary sources. So, and just to go back to primary sources, I'm sure all of you have had some experience in some class where you had to, maybe for a discussion board post or for an assignment, you had to access a primary source. It may have even been, you may have been specifically directed, find a case that says this, find a regulation. Yeah, Lauren, yes. So good. You know, look at your state's constitution and tell me what, you know, find, you know, a section that deals with this legal issue. Right. So excellent. That's why we need to know what the sources are. How valuable are these sources? What is their sort of level of credibility and importance, but then also how to access them. Secondary sources, books, treatises, dictionaries, ALRs, legal encyclopedias, periodicals, law reviews, bar journal articles. These are really helpful at helping you interpret the primary sources. You know, don't think that, you know, I remember when I first became a lawyer, or actually, no, I think it was maybe for when I first started teaching, people were sort of saying, wow, you must have an amazing memory. And at the time I did, but I was sort of like, well, what do you mean? Like, how does that really apply to the law practice? We don't really need that great of a memory. Oh, you memorize all the laws. No, 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 no. We would never do that. You know, first of all, it's impossible. And, you know, many older lawyers couldn't do that. I would say that myself. They would all be out of my head. But we simply learn the skills to find what we need to find the laws, to look them up. That right, exactly, Heather. We don't have to. There's no need. They change, so they may change so quickly too. So we're not, you know, our brain is not expected to be like this, you know, law library. We learn the skills to look up these things and find them. So lawyers, paralegals, anyone educated in the law, we don't automatically, you know, we read a case, we don't automatically know what it means. We may have to like look something up. Well, what does that term mean? You know, what is this section? You know, of the you know, Illinois workers' compensation statute. Like, I'm not really sure what that means. What does that terminology mean? How does that apply to my case? That's when we go to these secondary sources. It's always so nice, like if there's this, you know, legal issue that's confusing, to find a law journal article and like let somebody else who's sat there and researched it, let them interpret it for you so that, you know, you can just read their article and then, oh, all of a sudden I understand. These are also useful to us when you are writing papers, when you're tackling discussion board posts, and you're supposed to interpret something. Okay, so I've gotten a little ahead of myself, but I gave you the overview, and now we're going to look at these topics specifically. So what are primary sources? They're books and online websites that comprise the formal written statements of law issued by government entities. You know, and you can still go to law libraries. You can still go to physical law libraries, but a lot of the, most of the books, at least books that are relevant to the practice of law today, they will be online. So you can, and in fact, you know, if you haven't looked at our Purdue library recently, you really should. You know, fairly recently, probably in the past year, legal studies was asked to, you know, evaluate and suggest some new resources to add to the library. And we were just going through the library and like, oh my gosh, we have this. Wait, we have this. So our library is, and since that point in time, that is always my first step when I go to do research. We have so much. If there's something that you are looking for and you can't find, you know, ask the librarian. One other thing too, that's of note, you will see that the ABA, the American Bar Association, has great articles. I've always used those articles, and at some point they put up a paywall so you can no longer access them. Doesn't matter to us because through the PG library, we can access all that. So, right, Lauren, and I'm glad to see that you've used it. And so so they're more recent articles, we can access all of those. So primary source, so a work that contains the actual law, such as a statute or court case opinion, this is the law itself. So these are primary sources of law. When we look at federal law, the primary sources of law are the U.S. Constitution, federal administrative regulations, the U.S. Code, and federal cases. So any of those things, if somebody, somewhere asks you to identify a primary source and, you need one on the federal level, you're going to look at one of these. In terms of state law, we've got the state constitutions, state administrative regulations. So this would be our state level agencies, state statutes, codes, laws, and then state cases, state case law. So just to sort of, again, at the bottom of the slide, you'll see like the little contrast. A primary source is the work that contains the actual law, such as a statute or court case, a judicial opinion. A secondary source is a tool. So, think of like you're in a museum, and the actual artifact, that is your primary source. And then any of the tools that you use to work on that artifact, those are like your secondary sources. So, that's the legal encyclopedia, law review, or a legal dictionary. All of those sources are valid. Now, actually, I should ask Professor Valdez, you might know, is the Black's Law Dictionary, is that in our library? I haven't looked recently. And if it's not
either, I don't think it is.
Okay.
But I'll check.
Okay, thank you. Yeah, and we'll find out. But using a law dictionary, I think sometimes, and by the way, I believe there is an app for the Black's Law Dictionary. It costs money. But I do think it's not the Black's Law Dictionary. There are some other apps that you can access on on a smart device that are law dictionaries, that are free. But I think you can, Black's is the gold standard, but again, I think there's free versions now that there's so much out there. But okay, so yes, thank you, Professor Valdez. The free legal dictionary online works well too. Yes. What does the U.S. Constitution consist of? A preamble, 7 articles, 27 amendments, all primary sources of law. Hi, Jason. And again, this is where the PowerPoint is going to help you as a resource material. So you may want to save it in your little library of resources. Where do you find the U.S. Constitution? So say you are, in a class where you're supposed to interpret a section. There are several ways to access it: through Congress, National Archives. And then in terms of your state constitutions, essentially you're going to search the state name and then the word Constitution, and you'll be able to pull up your state's constitution. Here are 2 links for Indiana and Florida. And then in Westlaw, you access Westlaw through the PG library. You will see annotations. Statutes, codes, and laws. So statutes, they're also known as acts, are laws passed by a legislature. So this could be a state or a federal legislature. This is a body of formal law written by a legislature and is used to know what the law is specifically at that time or in the past. So you can find a current statute, or you can find, older statutes are available as well. They can be searched by section number or names, and then there are federal statutes and state statutes. Some state websites, you'll notice, have, they're all linked. And if you want to look at a specific section, sometimes they're sort of annotated and especially helpful, but it really depends on your state's website. So in terms of the legislative process, probably a lot of you, kind of know this already. I do think we start going over this. We mention it in intro to law and the legal profession. I remember posting the Schoolhouse Rock, I'm just a bill jingle that maybe some of us remember from Schoolhouse Rock many years ago. But this is just a brief reminder of the process. So yes, Heather, I'm just singing it in my head now. Legislation is first. Oh, that's right. LS 185 as well. Yes. So you're probably all experts, but we'll just review it one other time. Legislation is proposed as a bill. It's then introduced to the House of Representatives or Senate. Referred to committee is the next step. Then is voted on by the chamber in which it was introduced. And then it is sent to the other chamber. At that time, it may be amended or it may be voted on, or both. If amended, it's sent back to the original chamber for a new vote. Both chambers, though, must pass the exact same bill. And that is just a little kind of overview on the process. Where to find statutes. So I'm trying to think. We actually recently, one of my classes I was teaching, we recently had a discussion board post. Where do you find the statutes? Certain statutes. And so we actually took a little, field trip because it kind of came up as a question. We had an impromptu field trip in class, visited Westlaw, and then tried to locate kind of where we would find these statutes. It's fairly easy to access. So there are you can, of course, for federal statutes. The government sites are very helpful, thankfully. US Senate site, US House of Reps site. And then if you're looking for state statutes, again, state name, the state name is your search term, and then the word statutes or state name and legislature. And then here's two links as examples. What's great now is that most states have really good websites. Even 5 years ago, some might not have been so great, but everybody, we've all moved to the electronic world. So everything is much more user friendly. You can also look at Westlaw to find them. And then, of course, Hein Online. Both of those are through the PG library. And of course, if you ever have any difficulties finding anything, the librarians are very, very helpful. I mean, they're amazing and quite responsive. Here's a sample page looking at the 2023 season of the Indiana General Assembly. This is an example of state statutes. So what is case law? Again, this is probably a review for many of you, but you know what? Sometimes, we mention it in class, class you may be taking about case law, and, kind of like expect, oh, everybody understands and knows what this is. So that's why these sessions are kind of nice because it kind of like brings us back to this sort of common knowledge of what do these terms actually mean? What are we supposed to, do with these things? And so we're all on the same page in terms of our background knowledge of these topics that, again, in most classes, we expect everybody to kind of have the same level of knowledge of. So these are legal rules developed through court opinions. What is a court opinion? This is the court's written statement explaining its decision in a case often written by an appellate court. So, as you might imagine, this is a fairly important document to write. Their opinion, their reasoning, explaining their decision, sort of laying out the law. In many cases, judges have a law clerk, and the law clerk will write the majority of these opinions. Of course, the judge will go over that, and make sure they're, it's correct and they're on the same page. But these law clerks are generally law school graduates at the very highest percentage of their class. So they're sort of scholars in their own right that are assisting the judges with writing these opinions. They lay out the court's interpretations of constitutional, statutory, and regulatory law. Here is a little very appropriate photo. I think you'll hear a little bit about Loving later on too. And then we have and Loving is an example of case law that lays out the fundamental right to marriage. So that is what that case stands for. And that is sort of the law that it has established. I would say, Jason, like judicial opinion, judicial decision, case law. Are you thinking of a different term? I'm not sure. I can't think of it off. Yeah, the majority. Yeah. Well, if you find it while we're still here, Jason, let us know. Case law comes from court opinions, but not all court decisions or opinions at all levels are going to be considered case law. So we've got the federal court system, as you can see. I'm not going to go through the whole thing, but this is a great, you'll see this in textbooks for different courses, but I love having this graphic because it really sort of shows you how the federal court system is laid out. Yellow, I guess it's yellow or peach, are the trial courts, and then the blue are the appellate courts. And it sort of shows you the relationship between the different courts and just the different levels. So then we look at the state courts, and of course we can't look at all the state courts for 50 states, but we're in this, for the purpose of this discussion, we're going to look at Florida's courts. So they're divided into 4 levels. At the bottom are your county courts, then you've got circuit courts, district courts of appeals, and then at the top are is the Florida Supreme Court. You'll notice in some states, I think it's New York, the appellate court is the highest court in the state. And then the Supreme Court is right below it. So when you are looking, when you are working in a particular state, you want to make sure that you understand the levels of the court in your state. Concurring and dissenting, I mean, those are definitely the like portions of a judicial opinion, like making up. But I think, I don't know if Jason was asking like just the name of it, a court a judicial decision, like is there a different name? But yeah, those are definitely no. Yes, no, that's great. Okay, so the ones on the bottom are the trial courts in that pyramid, and then the top are the appellate courts. So case law, this is contained in the law reporters. The law reporters this is a published volume of judicial decisions by a particular court. The law report may be either official or unofficial. So just know what you're looking at when you're doing research. The opinions of the U.S. Supreme Court are published in a set of case books called the U.S. Reports. So where to find case law? PACER is where you find all the federal cases. I believe PACER, actually I have not worked with it in the context of PG. I think we can access it through the library, but I know if you're, working in a law firm, it is a paid subscription for that. And then we have a variety of links for state statutes. So administrative rules and regulations. So as you may recall, Congress gives powers to the agencies through enabling statutes. So they're only able to act through these enabling statutes. They can create law, which is primary authority, and their laws are called rules or regulations. So if you see something as a rule or regulation, it is a law, but it's administrative. These rules and regulations are initially published in the Federal Register. And yes, PowerPoint will be available, certainly. And then eventually they're published in the CFR. Here is an example. These are available, or a look at the actual book. These can be found in Westlaw, and then these are updated regularly. States may have similar types of publications for state administrative regulations. Where to find these regulations? Again, here's some great links. So I do think that, this is a nice reference PowerPoint because of the fact that, maybe it's something you want to, put in a little special folder of like these kinds of reference PowerPoints in the event that you have an assignment that, hey, I need to find out, where the state regulations are. How do I find those again? This one is repeated. Oh, sorry about that. Somehow we had a little repeat there. And then we've got, Oh, that slide does not want to go. I'm sorry. Books and treatises. I think it is something that has to do with transitions. And I'm sorry. Oh, it just transitioned again. I'm gonna kind of skip that slide. Books and treatises. Oh, there it is. Books and treatises. Books are legal textbooks. Treatises. I loved treatises in law school because if you needed special knowledge on a particular subject, you would go to the treatise and it would basically spell it out for you. Horn books were also very useful, and nutshells. These are resources that law students use a lot. I remember when I was in law school, people were like, that's cheating. It's not cheating. This is actually part of learning about the law, that you are kind of reading like, oh, this is a resource, and it kind of like, yeah, right. Like a cheat sheet. Yes. Thank you, Heather. That's exactly what I was trying to say. That slide. So then we've got ALR. Sorry, there's something weird going on. It's a ghost of my PowerPoint. The American Law Reports, these publish and analyze recent significant cases, and then they're fully annotated. Jason, they're exactly like Cliff Notes. They're exactly. And you know what? Cliff Notes were never wrong. There's nothing wrong with them. It's just when people didn't read the book and only read the Cliff Notes, but using them properly, it's fine. Yeah, I know. Hope you remember that ghost, right? Yes. Hope maybe it's something you and me in the class, and then the ghost likes us. So then we've got they're all collected by topic. So I'm going to go to the next slide and get rid of that ghost. Law reviews or journals. These are found by, yes, site, the Emmanuel. Yes, forgot about that. These are published by students, provide critical analysis, and often advocate change. So students have a lot more time to write, and they can let them do the research for us. We'll just, reap the benefits of them spending hours and hours, trying to improve their resumes and, position in their law school by being on the law review. Well, we're going to benefit from that and use their articles as part of our research to support our arguments. They can sometimes be cited in court even. And then we've got our miscellaneous secondary authorities, such as attorney general opinions, words and phrases, legal dictionaries. Oh, Martindale-Hubbell, that's a legal directory. Form books are great. Exactly, Jason, right. Uniform laws. Well, and Jason, when you think about it, that let the students, let the people with the more time do the work, and then the others will go out and generate the business that brings in the income of the firm or whatever law office we're talking about. Uniform laws, loose leaf services, and then jury instructions. All of these things help give insight into the topic that you're looking into. And then where to find these secondary sources, you'll find law reviews on the school website, professional organizations, and again, our law school library, our library at PG, which for all intents and purposes is as good as a law library. We have so many of these things. So, and then if not, we can share the resources as to how to locate and find these things. So at this point, oh my gosh, I have to find a way to pause this because I see what's happening here, but I'm going to turn the mic over to Professor Valdez, who will talk about briefing the case. So
Thank you very much. That was very informative, Professor Nolan. I appreciate it. And Professor Nolan started us off, our slides are wanting to advance for us, with the primary sources of law. And so we're going to focus in on case law and talk about briefing a case. So you can go ahead and advance it. Thank you. So a case brief is essentially a summary, a book report, if you will, of a court's opinion. Appellate courts will issue their opinions, and that interpret the law. The primary sources of law, our statutes, our constitutions, our regulations. The PowerPoint is faster than I am tonight.
Yeah, I may have to share this in a different way because I think the transitions are playing through. So I'm going to just stop it for a second. I'm sorry, and I'm gonna have to,
No worries.
I'm gonna have to just share it, in a way that's not as pretty, but it will allow us to, um, advance at our leisure.
Leisure. Perfect.
Okay, here we go.
Awesome. Thank you.
And is this the slide we were on? Oh,
The case
hold
brief,
on.
the next one. Perfect. Thank you. There we go.
There we go.
So once we have this opinion of the court, our role as the legal researcher then is to interpret it and use it to argue our points for our clients. So we need to be able to understand it. And thus the case brief comes in. So a FEREC case brief is essentially a short summary of that court opinion that is broken down into, it breaks down the opinion into smaller categories: the issue, the rule, the analysis, the conclusion. We use case briefs in research and writing. It's not something that you often will submit to a court, although I have been asked by a court to brief a new case that came out and submit the brief to the court. And when the court asks you to do it, of course you do it, but it isn't something that you're often asked to do. This is something that we work on in our office. Once you have briefed your case, you have that concise summary of the information in the case. You're going to hold on to it. The case isn't going to change. There may be subsequent cases that impact it, but you'll be able to use it in the future when that case should come up. Go ahead, Christina, we can advance. Thank you. Perfect. So one of the key reasons that we create a case brief is to make the court's opinions more understandable. Some justices, when they draft opinions, are eloquent and create these beautiful literary works that lead you to better understanding of the law and how it should be applied. And sometimes other justices or judges will draft opinions that are really difficult to move through. And you, exactly, you won't be able to really discern exactly what they're saying. And it'll take a couple of reads and some further exploration to really understand what the court means. So anticipating this going in is always important. You should expect to read the case more than once. As a matter of fact, with Supreme Court opinions, I often, every time I teach the case, I reread the case. But when a new case comes out, you have to read it 2, 3, 4, 5 times. And each time you read it, you'll find something new or some other tidbit within the case itself. The more case law that you read, the more familiar you will become with the formatting and with the language, and the more comfortable you will become with creating a case brief. The first few are a little, it takes a little getting used to because you're working with a new format and this new type of writing and reading. Okay, we can move ahead. So we're going to focus on a constitutional case. If you have had a class with me before, you will know that this is my favorite case. So we're using Loving v. Virginia. This case was decided in 1967 by the United States Supreme Court. The court at that time was called the Warren Court. The Chief Justice was Earl Warren. In the picture here, you can see Mr. and Mrs. Loving. Go ahead, Professor Nolan. So Supreme Court cases are full of information. They often give you a historical perspective and bring in all kinds of statutory and case law or regulatory law. And so it really helps to break these uh, court opinions down into sections. And I break it down into 3 reads. Okay, we can move to our first read. In the first read, we're going to identify the parties, identify the court, and then move through the opinion. Next slide. So we'll start with the parties here. The parties in this case are Mr. and Mrs. Loving. They are the plaintiffs. Our respondent here is the state of Virginia. So the issue, the problem is between the Lovings and the state of Virginia. Go ahead to our next slide. We look to see which court is deciding the case. This court citation has the U.S. reporter. I know that the U.S. reporter is the official reporter for the United States Supreme Court. And thus, I know that it's the United States Supreme Court that's deciding this case. If it was any other court, we would have the reporter information and we would have the court identified next to the year in that citation. We can move to the next one. You always want to know when the case was decided. This case was decided in 1967. So you'll want to make a note of that as well. And our next. So after we have that base information about the parties and the court that's deciding the case, we're going to move through and read the opinion. See what happened. Figure out what the legal question is and how that resolution was reached. Then we move into our second read. Now, I often like to take a little break in between my reads. Supreme Court cases can be very long, 20 pages, 30 pages, 50 pages. So it's okay to take a break. So on that second read, you take your time to begin to think about what happened in the case. You refresh with the parties, you look at the legal question. What is it that the court was trying to assess? And what kind of decision did they make? And after you finish that second read, we move into our third read, and that's when we brief the case. Tonight, we're going to talk about the FERAC method of briefing. This is where you break down the court's opinion into the FERAC headings: the facts, the issue, the rule, the analysis, and the conclusion. Now, you may have, go ahead, Professor Nolan, have heard of IRAC, Issue, Rule, Analysis, Conclusion. And this was all the rage in trending legal analysis, the IRAC method. But facts are really a great way to discern a case from one case from another. And in most instances, we fall back on the facts when we are discussing cases and trying to distinguish one from another. So the IRAC method quickly evolved into the FERAC method. We started adding a facts section in the front. So let's go through the FERAC method of briefing the case. We'll start with our facts slide. Perfect. So when we are drafting the facts section of the case, we only want to include the facts that are necessary to explain the legal action. Oftentimes, we have a whole narrative, all kinds of information that may or may not have legal significance in the case. Here on the right side, you can see the facts of the Loving case. This case is about Mr. Loving, who was a white male, and Mrs. Loving, Ms. Jeter, who was a black female. They were residents of Virginia, and it was unlawful for them to be married there. They were charged and pled guilty to a violation of law. They later appealed, got their sentence suspended, but only if they agreed to leave Virginia and not come back. They relocated to Washington and sought to have their convictions vacated. Then they instituted class actions on the grounds of the 14th Amendment, and that is the case that the court decided here. So this is a short summary of what happened that led up to the case. On the left side, you see a more succinct summary. Plaintiffs pled guilty to a violation of state statute prohibiting interracial marriage. Plaintiffs sought to have their convictions vacated as unconstitutional under the 14th Amendment. Right. Our facts. Next slide. Then we move in to assess the legal issue. What is the legal question being asked in this case? In the FERAC method, this is the second heading. Now, it's usually easiest when you're talking about the issue to phrase it in the form of a question. This is the question that the court is being asked to answer. This is why we're reading the case, for the answer to this question. Many legal issues will start with the term whether, W-H-E-T-H-E-R. This sets the reader up for that comparison, a yes or no answer. Sometimes cases will have more than one issue addressed. In that case, you would separate each issue individually. Perhaps they deal with a substantive issue, an issue about the application of law, and perhaps they also have a procedural appeal pending, maybe having to do with the entry of evidence. Okay, we can go to the next slide. So here are 3 examples of an issue for our Loving v. Virginia case. Now you'll notice our third issue is quite comprehensive. Hey, Professor Gray, thanks for coming. All 3 of these issues are correct. There's a bit of a wider leeway here. Remember, this is an inter-office document. So you will write the issue that makes the most sense to you, that lays out that legal question asked. Go ahead, Professor Nolan. Next, we're going to establish the rule. The rule is also called a holding, and it answers the question posed or the issue. Oftentimes, we will start with a yes or no, answering that whether question. If you have more than one issue, you're going to have more than one rule. Next slide. Here are rules that go along with our issue questions for this case. You can see how they parallel each other. Next slide, Professor Nolan. Thank you. Analyzing. The analysis section of the case brief is often the largest section. This is where you explain the why of the case, the rationale, the reasoning. This will be detailed, and it may include references to law relied on by the court. In an IRAC format, where you don't have that facts section, the facts would be included in this analysis section, along with the law, to get to that conclusion. Next slide. Thank you. So the analysis section, I'm going to address Tiffany's question real quick. When writing the issue and rule, do you do it separate or together? It's totally up to you. I personally uh, write each section separate. Sometimes I will figure out the rule first. Sometimes the court will even expressly tell you the rule. Sometimes the court will expressly tell you the issue. And when they do that, it's always a wonderful day because it's very easy then to fill in that portion of the brief. And sometimes you'll have to devise it. But there is no set right or wrong way to do it. Sure. So the analysis section is where it all comes together. You explain the path that the court took to get to that conclusion. So in this section, you have to have enough information so that when you reflect and you read your case brief, that you understand that process and you could walk through that process, do that application for whatever your client case on point that you need this case for. So on the right side of the page, you see an example of a short analysis for this case. Okay, next slide. And finally, the conclusion. The conclusion is where you tell the final results of the case. What was that end point? Here, the plaintiff's convictions were reversed. Here's a picture as well of the United States Supreme Court, the Warren Court that decided this. Notice this was the court in 1967. Quite different from our courts today. Right, next slide. Now, I wanted to point out here that there are various forms of case briefs. Tonight, we have gone over the FERAC version. It is a shortened form, and it was kind of, I don't know if it was relatively new when I was in law school an eon ago, but it really was coming into its own. In law school, they taught us a traditional method of case briefing, and you'll notice it has many more sections in the case brief than the FERAC format: procedural history, facts, issue holding, analysis application, disposition, dicta. The traditional method, and if you take LS 204, you're going to brief a case using this more traditional method. If that's legal research and writing. And we practice a FERAC case brief in LS 244, advanced legal research and writing. So neither form is right or wrong. It's really a preferential. The traditional format allows you to break it down into smaller component parts. And we were discussing earlier the majority opinion and a dissenting opinion where one of the justices sitting on the panel doesn't agree with the majority and thus writes an opinion where they disagree and they walk through the rationale that they take in the case, reaching a different decision. And that can be included as a separate point in a traditional case brief, or in the dicta section, we can include that sometimes as well. I like to create a separate heading for that. Yes, for the case brief, we're looking to pull, we're using the case as a research format, right? So the rule that the case develops, that precedent, that's what we're looking to pull this. How are we going to use the decision in this case and apply it in our client situation to argue the law in their favor? Right. The application of it? Yes. Okay, the next slide. Absolutely. So just a traditional method, FERAC method, another layout of where you may run into it. It is preferential. Some of us old schoolers will prefer a traditional method. The FEREC is nice and concise. I'm a big fan of it as well. And finally, go ahead, Professor Nolan. You're in the right spot. Yes. There are two different kinds of briefs. I wanted to take a moment and distinguish this. Tonight, we've talked about a case brief, that summary of a court's opinion that we use interoffice as a research tool in creating our arguments and crafting our analysis. A court brief is distinguishable. Case briefs are usually a page, 2 pages in length. We used to try and keep them concise. Again, it's a summary of a larger writing. A court brief is not concise or brief at all. A court brief is filed with the court in support of a legal argument being made to the court. We file an appellate brief when we file an appeal, and we're going to make an argument to that appellate court as to a procedural or substantive error that happened in the lower court. That court brief that we file will outline our argument, all the law we rely on, and what we're asking for that appellate court to do. So a court brief, one that's filed with the court, is a very, very different document than our case brief, which is a research tool. Okay, absolutely. You can find a plethora of information across the internet. We saw many websites in Professor Nolan's section of the presentation where you can find these primary sources of law online, secondary sources as well. These are some of them. But you can also make use of the law libraries at law schools across the country, including Purdue Global's law library. So don't hesitate to reach out, if you want to go to our next slide, Professor Nolan, to myself or Professor Nolan. If you have any question, there is our contact information. And we want to open the
And also,
floor.
if anyone has any questions now,
Yeah,
we can take, we have
exactly,
a
for
few
questions.
minutes, we can take some now.
We will post it on the Legal Studies YouTube channel. And I'm not sure if it's posted anywhere else.
Tiffany, that's amazing.
It's cool.
Tiffany, technically that's my maiden name too, but I did keep my name. Thank you, Lamonda. I'm so glad you enjoyed it.
Coming.
Desiree. Wonderful.
Oh, thanks.
Tiffany, no. The Nolans are from Massachusetts. And again, I know we mentioned the Legal Studies YouTube channel. This will be there, but there's other very informative videos. And it's also the YouTube channel is a work in progress. So you'll see a lot of informative videos there right now, but they are being added on a regular basis. So it's something you may want to subscribe to, and I believe then you get notifications whenever a new video is posted. Tiffany, oh my gosh, that's awesome. Does anyone happen to have the link to the YouTube channel handy to put in the chat?
Right at our start.
I think Gurman put it in there at the beginning.
Right. So I'll see if I can grab it and put it back in.
Great Hope.
Did you say, I know you did, where they could find the PowerPoint presentation?
I'm
not sure where it's uploaded to.
Hold on a moment. If anyone wants the PowerPoint, I'm gonna do something very, very tech savvy for you. There it is.
That's awesome.
We
Way
might
to go.
Oh my gosh.
Ah, look.
Worthy.
should have done that earlier, but Yeah, so, but I believe will it be somewhere else? You know what? Maybe we can try this. I'm not sure if this is possible, but if we can get the list, I don't know, if we get the list of guests, sometimes you can send an email, but we'll see if we can do that.
I'll
Um,
post it in my classrooms as well.
And feel
Yeah.
free to use one of our emails, email Heather or I, if you're not able to
Absolutely.
access it, we'll send it to you.
We would be
So
delighted to.
great,
Great.
Lauren.
Oh, great. Awesome. I'm very impressed that you were able to share that.
I
Professor
know.
Nolan.
That's so wonderful.
Yeah, that was awesome.
Awesome.
Yay. Well, thank you for coming. It was a pleasure to be here with all of you.
Yes,
And thank you,
We had a wonderful
Professors
turnout.
Nolan and Valdez. Every year it's better each year. So it's just wonderful.
Nice to see you, Micah.
Great.
Thanks to the Law Society for inviting us.
Well, thanks for thanking. I'll go ahead, I guess, and stop the recording and then say goodnight to everybody. And I like they both professors have said, if you want to contact them for any questions after this is over, you can certainly do that. So good night, everybody, and thank you for attending.
Good night, everyone. Thank you.
Thank you all. Good night. Good night, Lamonda and Tracy and Justin.